and since I'm recording and uploading this to YouTube. So the Johnson Control Company manufactured batteries, which exposes workers to numerous hazardous materials, but particularly lead, with regard to the manufacturing of batteries. As a result of that manufacturing process, the company had a rule which prohibited women from working in jobs that might expose them to such hazards because of the potential that women might get pregnant, and that would ultimately lead to unhealthy exposure of the fetus. So the company had a rule that would not allow women to be employed in certain job titles because of fears that the woman would get pregnant and that would lead to unhealthy outcomes in terms of pregnancies. And therefore women were systematically excluded from that area. This exclusion didn't apply to all women, but just to women who were capable of bearing children, quote unquote, and that's how the company entitled it, which simply I presume to interpret as women of childbearing years. So women of childbearing years were prohibited from working within certain titles. So this comes before the court. All of the justices agree in the outcome. So it's a 9-0 decision on the outcome. It's a 6-3 decision with regards to the majority opinion. The majority opinion in this case is written by Justice Blackmun. The Supreme Court holds that this policy was barred by the Pregnancy Discrimination Act of 1978. So that first prong of the Pregnancy Discrimination Act is upheld as constitutional in this case. Question. No, not at all. Let me actually do the case. In the majority opinion, Justice Blackmun writes, fertile men but not fertile women are given a choice as to whether they wish to risk their reproductive health for a particular job. This company's fetal protection program explicitly discriminates against women on the basis of their sex. So in this case, men were given the choice about whether they wish to be employed. They could possibly have the same health outcomes. Granted, they would not be carrying the child, but they could also damage the reproductive health by the access to these dangerous chemicals. But they were given a choice about whether or not to do that, and women were summarily prevented from doing that. And so in this case, that the rule in question violates the Pregnancy Discrimination Act. In fact, as it came out in the trial of the case, there was some evidence that lead were much more harmful in terms of reproductive health to men as opposed to women. And so the court ultimately argues that the choice must be empowered to the actual individual, whether it be male or female. If men can opt into this employment, women should similarly be able to opt into this employment. And it's at that point, Michael, which I think is what you're getting at. Once you opt into that employment, the company can absolutely make you sign a liability shield, recognizing the risks that would be involved if you were someone who was seeking pregnancy might get pregnant. So they would be protected in that sense, but the federal law, the Pregnancy Discrimination Act, didn't protect them. It's upon signing the employment contract that the company in question would also tell them of the risks and allow them to opt in to that with acknowledgement of the risks, and also clearing the company of any liability of risk that might stem from that sort of practice. So the first prong of Pregnancy Discrimination Act is still considered to be good law. And going forward, we now recognize that discrimination on the basis of pregnancy is in essence a civil right, and companies, private or public, cannot discriminate on the basis of pregnancy in terms of employment.